layman, how is it that I can make use of this pre-institution mediation?
First mediate, try to get an effective result. If there is no effective result, then only you can go to the court, you may go to the court.
Yes.
We'll assume that there is a dispute between you and the developer.
So when you mentioned that you gave this example, instead of 15 lakhs, maybe the developer would agree for 12 lakh. Can it also be a situation that the developer would also have certain claims against the...
So this is a platform where the government and the judiciary is giving, asking the parties to resolve the dispute amicably before a neutral third party, namely DLSA.
So let us discuss with an example. So let's consider that I am in construction activities. I provide construction for various developers. So to do these construction activities, let's say I've entered into an agreement with another company or a person or a partnership firm where who will supply the materials, raw materials required for purposes of construction. So now if in case I've paid the advance, but there is no delivery of the construction material and there is a dispute, as a layman, how is it that I can make use of this pre-institution mediation?
Yes. Firstly, construction activity is a dispute under the Commercial Courts Act.
Yes.
So any dispute pertaining to construction should be in the commercial court.
Yes.
That is to say, the jurisdiction will vest with the commercial court.
Commercial court. Yes.
Having said this, the contractor, we'll assume that you are a contractor, your illustration says that you are a contractor.
Yes.
You cannot directly go to the court unless you have an apprehension that the person, that is to say the defendant, is likely to run away or likely to sell the property which could be the subject matter of your dispute.
Yes.
That is to say, we call it as injunctive reliefs.
Yes.
If there is no such apprehension that there is such injunctive relief is necessary, then you are bound to go through the entire process by adopting to or going to pre-institution mediation.
Okay.
That is to say, the concept is first mediate, try to get an effective result. If there is no effective result, then only you can go to the court, you may go to the court.
Yes.
We'll assume that there is a dispute between you and the developer.
Yes.
The disputed amount is, say, we'll assume 15 lakh rupees.
Okay. Which satisfies the 3 lakh specific.
Yes, you're right. Yes. It is about 3 lakh rupees.
Yes.
Upper, there is no limit. It could be any amount.
Any amount.
So that 15 lakh rupees is the amount. Usually you will not directly go to a court. You would probably go to an advocate. You would send a notice. The developer receives the notice. He responds. He may deny, saying that I am not liable to pay.
Yes.
So the dispute is created.
Yes.
Now, usual scenario, in a civil court, it will go before a civil judge or a civil court. Here, now that this is a commercial dispute, it will go before a commercial court, but you can't directly go to the commercial court. You have to first lodge by filing a pre-institution dispute, that is a mediation, pre-institution mediation before the District Legal Services Authority.
Okay.
We'll assume that you are in Shivamogga.
Yes.
You are a contractor in Shivamogga. The activity which is taking place is we'll assume it is in Bhadravati.
Okay.
Now, we have the concept of cause of action.
Yes.
Could be that Shivamogga also has jurisdiction. Maybe that Bhadravati also has jurisdiction.
Yes.
So you can choose.
Okay.
You can choose to go to the District Legal Services Authority of Shivamogga, where you reside or where your activity is.
Yes.
Or you can probably go to Bhadravati District Legal Service Authority, where you can go and file a Form 1, that is called as the form which is to be filed.
Okay.
It is to say it is a sort of an invitation to mediate.
Okay.
This is the entire authority, competent authority is the District Legal Service Authority.
Okay.
What you have to do as a contractor is fill up the Form 1. It's a very simple form. It is about 1 page.
So I'll just pause you for a moment here. Where can I find this form?
It's actually available on the net.
Okay.
You can do it even online.
It is a publicly available
It's a publicly
document.
available document.
Yes.
Or you can approach the District Legal Service Authority. They actually are the initiative of the High Court of each state.
Okay.
Under the jurisdiction of the district administration of the judiciary. So that office will be there. That District Legal Service Authority office you can approach. It's a one small form. Fill up that form. It requires only small information. You and your details, your developer who is your opponent, his name and details and phone numbers. Then nature of dispute, just to show that it is a commercial dispute. What is the amount involved? Maybe 15 lakh, that is called a specified value. That's all. You have to pay some 1,000 rupees as the initiation charges.
Okay.
Once you give that, we'll assume that you did it in Bhadravati. The Bhadravati District Legal Service Authority, the office, will generate a notice. It is going to the opposite party, namely the developer. He receives this. What is that? Here is contractor who has come. He says there is a dispute with you. Are you willing for a mediation? It's actually an invitation for mediation. Please note, you are not given any plaint. You are not
Yes.
filed a case.
Yes.
It is only a form
Yes.
inviting your opponent for a discussion.
Yes.
The discussion takes place in a neutral third-party forum, namely the District Legal Service Authority. So once the notice goes to your opposite side, he willingly accepts for a dispute being discussed in the mediation. You agree, he agrees, both of you agree for mediation.
Yes.
Then there is a fee which you have to pay. That fee depends on the quantum of the dispute. Both have to deposit that, then the mediation starts.
Okay.
So the mediator will come in there. The concept of mediation is another thing. It could be another chapter which another day we can discuss.
Yes.
In the process of mediation, both of you agree.
Yes.
I'll just give a live example. You agree that I am due 15 lakhs, but I am agreeing to take it only 12 lakhs in view of this discussion and settlement. Maybe there is some genuine reason where you also accept that probably 15 lakh is now to be revised to 12 lakhs. We'll assume the developer says, I am ready
There's
to
a
pay.
set off sort to be made.
Set off to be made against
Yes.
that
Yes.
amount. So agree, that becomes a settlement.
Yes.
That is to say, contractor agrees to take the money from the developer, quantified at rupees 12 lakhs, in maybe installments. Developer may not have the amount. He may say, I'll pay it before 31st of December 2024 in phased manner. So the settlement is arrived between the developer and the contractor where the money is agreed,
Yes.
quantified at a particular price, that is to say 12 lakh rupees. Term is agreed, liability is accepted. He also agrees to pay the entire amount in so many installments within that so many period. That becomes a settlement. So that is called as a memorandum of settlement, which is
Okay.
facilitated in the presence of the mediator.
Okay.
So mediator, appointed by the District Legal Service Authority, facilitates the two parties
To settle all
the
the
dispute.
So when you mentioned that you gave this example, instead of 15 lakhs, maybe the developer would agree for 12 lakh. Can it also be a situation that the developer would also have certain claims against
Possible.
the one who bought the case? So even that, can that also
Yes,
be settled?
yes, definitely.
Which was not, so the pre-institution mediation was not initiated by the developer.
Yes.
But yet, during the mediation process, it can be made use
Yes,
of.
he may say that I too have a dispute. We call it as a counterclaim.
Yes.
Mediator
Yes.
takes that also into account.
Yes.
So claim, counterclaim, both will
can be
discussed
settled
in the
Yes.
same time.
Yes.
What would have otherwise gone to the court is
Yes.
done in the mediation. You may not settle,
Yes.
but at least you know the mind frame of your opponent.
Yes.
That also helps you to focus on your proposed litigation,
Yes.
namely filing of a case in the commercial
Yes.
court in Bhadravati or Shumoga later.
Yes.
So this is a platform
Yes.
where the government and the judiciary is giving, asking the parties to resolve the dispute amicably before a neutral third party, namely DLSA, where the mediator facilitates as a neutral third party and tries to understand the difference between the parties and tries to narrow it down or resolve it.
Yes.
There is one more concept. What happens to the settlement arrived there? We'll assume that you have gone to Bhadravati, you have settled with the developer, he says, I will give you 2 lakh rupees. He has to pay the first installment, we'll assume by 31st of December 2022.
Yes.
He says, I will pay 5 lakh rupees by 31st December 2022. 31st December, agreement is signed,
Yes.
party signs, advocate, if necessary, if he is there, he also signs, opposite party signs, his advocate also signs, mediator also signs. The settlement signed in the mediation is as good as a decree of the court.
Yes.
Please see, in the event on 31st December, that 5 lakh is not paid by the
By the developer.
to the contractor, On 1st January 2023, if he wants, the contractor can go to the court where otherwise he would have gone to file a case for
Yes.
executing that money, asking for that money, recover that money by filing that case. In other words, the decree, the settlement operates as a decree. By that, what would have been, otherwise he need to file a case,
Do the evidence.
the rigmarole of all this, filing a
Arguments.
case, paying court fee,
Yes.
then, the other side appearing, cross-examination, filing documents, proving your case, the judge passing judgment, we can call it as 5 years. That 5 years is avoided. So from pre-institution, settled, you skip the admission
Yes.
to commercial court. You directly go to the next stage. Pre-institution, not settled, then only you get admitted to the commercial court.
Yes.
So this is a concept which is very new to India, very, I would say, very special. Particularly because I would say it's a game changer for this reason. This concept is introduced in commercial law,
Yes.
namely commercial disputes.
Yes.
Because there is not much of emotion involved.
Yes.
It's only some serious differences. Individually, the parties are not involved emotionally, unlike in some family disputes, partition disputes.
Objectively, the settlement can be arrived
Yes,
at.
because the commercial interest overweighs all other interests.
Yes. Yes.
Maybe
Settlement
temporarily
can-
had certain reasons.
Yes.
He was not able to pay, but he is also keen to see that he retains a good level of understanding and commercial relationship with you, the contractor. So
Yes.
both will be looking at commercial viability.
Yes.
So this is one advantage of the commercial court mediation concept.
Yes.